Here's Myriam Gilles. She is the professor of law at the Benjamin N. Cardozo School of Law. And in this clip that you're going to hear from a hearing that took place in the House Judiciary Committee on November 16th of last year, she's going to refer to the FAA, which is the Federal Arbitration Act, which is the law that allowed the arbitration system to exist and have its judgments be honored by the real courts.
The FAA was enacted in 1925, but it was enacted so that sophisticated business people could negotiate for arbitration provisions, and those provisions would be respected by courts. It was never intended to be imposed via standard form contract. And in fact, if you read the legislative history, if you read the legislation, it accepts and exempts employees. So the idea that the FAA applies to employees is something that was created by a conservative majority of the Supreme Court in 1991 in a case called Circuit City. First actually was Gilmer and then Circuit City. I can't keep all the bad cases straight. And those were the cases in which the court interpreted, I would say misinterpreted the FAA to apply to employees like this. So that now employers can just stick these clauses into job applications, orientation materials, even an innocuous email from HR can include a forced arbitration clause.
And another witness in the hearing, Deepak Gupta, who's a law professor who used to work at the Consumer Financial Protection Bureau, he seemed to share her interpretation of the situation.
I've gone back and looked at the history of the act from 1925. Congress put in a provision, Section 1 of the Federal Arbitration Act, that says this shall not apply to any class of workers. Remarkably, the Supreme Court has read that language to mean precisely the opposite, and now it can apply to any class of workers. We've strayed so far away from what Congress intended in 1925, and that's why only this body, Congress, can set things right.